A groundbreaking development is unfolding in the fight for gun rights, and this one could change everything. Connecticut's ban on certain firearms is now making its way to the Supreme Court, and the legal challenge being presented is unlike anything we've seen before. This isn't just another routine appeal that will get lost in the shuffle. This is a carefully crafted, strategically important case that could force the highest court in the land to finally answer a question they've been avoiding for years. Before we get into the details, I need you to do something really quick. Smash that like button right now if you care about protecting your Second Amendment rights. It only takes a second, and it makes a huge difference in getting this information out to more people who need it. Also, if you're not already subscribed to the channel, hit that subscribe button and turn on the notification bell so you don't miss any future updates on your rights. Trust me, you're going to want to stay informed about this stuff. Here's what makes this different from all the other challenges that have come before. The Connecticut Citizens Defense League and the Second Amendment Foundation have teamed up with two individual citizens, Eddie Grant and Jennifer Hamilton, to ask the Supreme Court one incredibly straightforward question. They want to know if the Second and 14th Amendments protect the right to own semi-automatic rifles that Americans commonly use for legal purposes, including the AR-15, which happens to be the most popular rifle in the entire country. There's no beating around the bush here, no complicated side arguments, no confusing legal technicalities, just one simple and direct question that demands an answer. This laser-focused approach is exactly what makes this case so dangerous for states that have enacted similar bans and so promising for those who believe in constitutional gun rights. Connecticut has a sweeping law that prohibits people from buying, selling, or even possessing a long list of guns that the state calls assault weapons. But here's something important to understand. The term assault weapon isn't actually a real technical classification. It's a political label that was created back in the 1980s to blur the lines between fully automatic machine guns and regular semi-automatic rifles that everyday people use. This distinction matters enormously because fully automatic weapons, which fire continuously when you hold the trigger, have been heavily regulated since 1934 and effectively banned from new civilian ownership since 1986. Semi-automatic rifles, on the other hand, fire one shot per trigger pull, just like most handguns and countless other firearms that Americans have owned for generations. According to Connecticut's rules, if a semi-automatic rifle has certain features that look a certain way, or if it can use detachable magazines, or even if the barrel or overall length doesn't meet their standards, it gets slapped with the assault weapon label and becomes illegal to own. These features are largely cosmetic and ergonomic, things like pistol grips, adjustable stocks, or barrel shrouds. They don't change how the firearm actually functions. A rifle without a pistol grip fires exactly the same way as one with a pistol grip. But under Connecticut's law, that cosmetic feature can be the difference between legal ownership and a felony conviction. Breaking this law means facing felony charges with mandatory jail time attached. We're not talking about fines or misdemeanors. We're talking about serious criminal penalties that can destroy someone's life. The law targets over 70 specific firearms by name, along with copies of those guns, pistols with braces, AR-style rifles, and rifles with common ergonomic features. What it really amounts to is a ban on the most widely owned type of rifle in America. The legal petition attacking this law makes a powerful case, and if the Supreme Court sticks to the principles it laid out in previous landmark cases, Connecticut's ban shouldn't be able to stand. Neither should similar bans in other states like Illinois, New York, California, Massachusetts, and Washington, which have enacted nearly identical restrictions. Let's break down the main arguments in this petition, because they're absolutely devastating to Connecticut's position. First, the AR-15 is the single most popular rifle in America, and it's not even close. Estimates put the number somewhere between 20 and 30 million in circulation, though many believe the actual number is much higher than that. Think about that for a moment. There are more AR-15s in this country than there are Ford F-150 pickup trucks, which is saying something considering the F-150 has been America's best-selling vehicle for decades. Surveys indicate that anywhere from 16 to 25 million Americans own one, and again, that number might be conservative. These aren't rare weapons locked away in military armories. They're in homes and gun safes across every state in the nation. Calling something that millions of Americans own unusual defies logic and common sense. Second, people use AR-15s for perfectly legal activities every single day. This isn't speculation or theory. Owners rely on them for protecting their homes and property, target practice, firearms training, hunting, defending themselves and their families, and being prepared in case law and order breaks down. Data from the National Shooting Sports Foundation shows that millions of people train with these rifles each year. Shooting ranges across the country see AR-15 owners regularly working on their marksmanship skills. Hunters use them for everything from varmint control to hunting deer and hogs. Competition shooters use them in organized sporting events. People who live in rural areas where law enforcement response times can be lengthy depend on them for protection. People use them for sports shooting and home defense constantly. These are lawful, constitutionally protected activities that millions of Americans engage in without incident. Third, actual crime statistics completely undermine the argument that these rifles are exceptionally dangerous or that banning them would meaningfully reduce violence. FBI data reveals that rifles of any type, including ARs, account for only a tiny percentage of homicides in America. We're talking about a fraction of total murders. Handguns are used in crimes 18 times more often than rifles. Even knives, hands, and feet are responsible for more deaths each year than rifles. Let that sink in for a moment. More people are killed with bare hands than with the rifle that politicians claim is uniquely dangerous and must be banned. If Connecticut applied its logic consistently, handguns would need to be banned too, but the Supreme Court already ruled against that idea in a previous major case. The court specifically said that handguns cannot be banned because they're the preferred choice for self-defense in the home. Well, if handguns can't be banned despite being used far more often in crimes, how can states justify banning rifles that are used far less frequently in criminal activity? The lower court that upheld Connecticut's ban used reasoning that the petition tears apart piece by piece. The Second Circuit Court of Appeals, which covers Connecticut, New York, and Vermont, issued a decision that was so contradictory and so inconsistent with Supreme Court precedent that it practically begs for correction. The appeals court actually admitted they were confused about whether AR-15s even count as arms protected by the Second Amendment. Yes, you read that correctly. A federal court said they weren't sure if one of the most popular firearms in American history qualifies as an arm under the constitutional amendment specifically written to protect the right to keep and bear arms. That level of confusion at the appellate level shows just how desperately the Supreme Court needs to provide clarity. The lower court also watered down the historical analysis they were supposed to use. Recent Supreme Court decisions have been very clear that gun regulations must be consistent with the nation's historical tradition of firearm regulation. Courts are supposed to look at what kinds of laws existed when the Second Amendment was ratified and in the years following. But instead of doing that rigorous analysis, the Second Circuit gave too much weight to what modern lawmakers decided instead of focusing on constitutional rights and historical traditions. The Supreme Court has specifically said not to do this. Courts aren't supposed to simply defer to legislative judgments about whether a gun law is a good idea. They're supposed to determine whether the law is constitutional based on text, history, and tradition. And perhaps most absurdly, the appeals court claimed a firearm could be dangerous and unusual even if millions of people own it. This is the complete opposite of what the Supreme Court has already said in previous cases. The Supreme Court has explained that weapons in common use for lawful purposes are protected by the Second Amendment. The test is whether something is commonly owned and used, not whether judges or legislators think it's dangerous. You simply cannot call something both commonly used and unusual at the same time. It's a logical contradiction that makes no sense. Either something is commonly owned by millions of people, or it's unusual and rare. It cannot be both simultaneously. This is exactly why the Supreme Court needs to step in and provide definitive guidance. Lower courts across the country are all over the place on this issue, reaching wildly different conclusions based on the same constitutional text and the same Supreme Court precedents. Different circuit courts are saying completely different things, creating a patchwork of inconsistent rules that vary depending on where you live. One circuit says ARs are protected arms but can still be banned anyway. Another says they aren't arms at all. Another calls them essentially military weapons that fall outside Second Amendment protection. Another court looks at how lethal they are and what alternatives exist for self-defense. Some courts consider common use at one stage of the constitutional analysis, while others consider it at a different stage. It's a complete mess of conflicting rulings that leaves both gun owners and law enforcement confused about what the Constitution actually protects. One of the most powerful statements in the petition points out that AR-15s are the modern versions of the rifles our ancestors used when America gained its independence. This isn't just patriotic rhetoric. It's a historically accurate observation that reminds the court of the long tradition of civilian firearm ownership in America. Repeating firearms, guns that could fire multiple shots without reloading, existed in the 1700s when the Second Amendment was written. The Founding Fathers knew about these weapons and never suggested they should be banned or restricted. High-capacity firearms existed long before the AR-15 was developed in the 1950s. Semi-automatic firearms, which automatically load the next round after firing, have been in common civilian use for over 140 years. The first practical semi-automatic rifles were invented in the 1880s, and by the early 1900s, they were widely available to the American public. The Founding Fathers welcomed technological progress in firearms. They didn't write the Second Amendment to protect only the muskets of their era. From the Belton rifle that could fire 16 shots in rapid succession to the Girandoni air rifle that Lewis and Clark took on their famous expedition across the American West, history shows a clear tradition of Americans owning the most advanced firearms technology available. The Girandoni rifle, by the way, could fire 20 shots before needing to be reloaded and was powerful enough to hunt big game. If the founders thought repeating, high-capacity weapons should be restricted, they had the opportunity to say so. They didn't. Instead, they wrote an amendment protecting the right to keep and bear arms without qualification or a limitation based on rate of fire or capacity. The petition cites numerous Supreme Court cases and even quotes recent writings and warnings from individual justices. One justice specifically warned earlier this year that the AR-15 question must be resolved in the next term or two. Well, this is that next term. The timing couldn't be more perfect. The petition is essentially asking the Supreme Court directly to take this case and finally settle this question once and for all. If you found this information valuable, do me a favor and hit that like button right now. It helps get this critical information in front of more gun owners who need to know about these changes. And if you haven't subscribed yet, make sure you subscribe to the channel and turn on notifications so you never miss an update on your rights. Share this video with every gun owner you know because this information is too important to keep to yourself. Thanks for watching, and I'll see you in the next one.